Good evening, ladies and gentlemen. I wish to welcome you to Social Work Hub. We are going to be we are going to continue on our our series on conflict management. Today, we're going to be looking at arbitration and alternative conflict resolution. Now, disputes have often been taken to formal courts. Litigation, however, can be expensive, time consuming, adversarial, technically demanding, and inaccessible to many people, particularly those in economically disadvantaged or geographically remote communities. These limitations have contributed to the growing importance of alternative dispute resolution. ADR refers to broadly broadly to processes through which disputes are managed or resolved outside or alongside conventional court litigation. Arbitration refers to is a dispute resolution process in which conflicting parties agree to submit their dispute to one or more impartial third parties known as arbiters who hear the case and make decisions. Now, in arbitration, parties involved in conflict submit this dispute to one or two impartial group or individual who will help them to resolve that conflict. Now, unlike mediation, where the mediator generally helps parties reach their own agreement, an arbitrator, an arbiter usually has authority based on parties' agreement and applicable law to make a decision on the dispute. Now, the decision of an arbiter may be binding, meaning the parties are expected to comply with it, or non-binding, non-binding, depending on the agreement and applicable legal framework. So, like I said, in arbitration, the conflicting parties goes to an external body, a neutral people, and submit the case to them. Usually is a higher authority, but it's not a conventional, most of the time, it's not a conventional legal system like the court. So a typical example I will give you is my father's land in the village that was disputed over by another family. So we took that case to the traditional ruler of a neighboring community where the land is situated. And the traditional ruler of that community served as the arbiter. So we were invited and we followed the process. So we are going to be looking at the characteristics of arbitration. So you see the characteristics. We are willing. We submitted. We are willing, and the party was neutral. So and the traditional ruler was able to adjudicate the matter, follow a process. We submitted evidence. There was hearing. There was procedures, and a decision was reached. you know. So, and the decision can be restorative or apologetic or whatever, but the decision was reached, and at the end of the day, we got some portion of that land, while the other party also got a portion of that land. So we got one. The land was 1.5 plots. We got one plot because every evidence showed that the land actually belongs to us. But we are going to be seeing the characteristics of arbitration. It can be flexible. You understand? If it is a court, once it is established that we own the land, we bought the land legally, there's no way those people will be given half plot from that landed property. But because it's arbitration, and it's also an alternative resolution, or alternative dispute resolution, yeah, ADR, because it's ADR. The traditional ruler gave the other party half plot and gave my family one plot. You see, it's flexible. So we're going to be looking at the characteristics of arbitration, and you are going to be seeing the examples I just gave. So, number one, arbitration commonly has the following characteristics. Number one characteristic is a neutral party. A neutral party. So we get someone, the conflicting party gets a neutral arbiter, somebody that will not favor the other person and favor this person. So a neutral person to adjudicate the matter. Number two characteristic of arbitration is that consent or legal authority. Consent. So arbitration commonly arises from an agreement between the parties, although specific legal systems may provide circumstances in which arbitration can occur through other mechanisms. Number three characteristic is structured process, structured procedure. Parties normally have an opportunity to present their case. Pardon. Structured procedure. Arbitration generally follows procedural rules. Defined procedural rules. So, in that particular case of my father's land, rules were followed. At a point, the other party actually put juju in the land. So, as the process of arbitration, the traditional ruler said that those parties should remove the juju that they put on the land. And that is the conventional rule for adjudicating on a land matter. So they can't bring what they call ma or deity into the land and they will adjudicate on the land. They have to legally remove the deity or the juju as it's called in this side of Nigerian state. So that was how so it followed a legal a particular procedure. Now, opportunity to present the fourth characteristics of arbitration is opportunity to present evidence. Parties normally have an opportunity to present their cases, evidence, document, and argument. We did that in that land case. Decision by arbiter. Number five characteristic, decision by arbiter. The arbitrator evaluates the information presented and issue a decision or award according to the applicable rules. Then the number six characteristic is arbitration proceedings. Arbitration proceedings are generally conducted privately. Proceedings are generally conducted privately, although the precise degree of confidentiality depends on the applicable rules and agreements. Now, what we mean by privacy as a characteristic of arbitration is in the law court, sometimes they video the proceedings. You understand, it's public, but in arbitration, it could be the two parties involved. It is a limited um, group of people that engages in arbitration. It's not a public stuff where people can come for a lot of people can come for court hearing. So it's usually a private engagement. So the seventh characteristic of arbitration is that it is flexible. Just like I told you, the decision was flexible. The traditional ruler decided to give a larger portion of the land to my family, while giving the other portion half half portion of the land to the other family. So it was flexible. So compared with conventional litigation, like I said earlier, arbitration can provide greater flexibility concerning venue, scheduling, choice of decision maker, procedural arrangement, and technical expertise, and even decision. Now, we have arbitration processes. Arbitration processes. Although procedures vary according to applicable law, institutional rules, and in agreement between parties, arbitration generally follows several stages. Arbitration follows several stages. And number one is agreement to arbitrate. So we will have to agree, the parties have to agree to arbitrate. The parties agree that their dispute will be submitted to arbitration. The parties agree that their dispute will be submitted to arbitration. The arbitration agreement may be included in a contract before a dispute occurs or made after a dispute has arisen. Number two processes of arbitration is selection of arbitrator. Selection of arbitrator. The parties select an arbitrator or arbitration panel. The arbitrator should possess relevant expertise, independency. Selection of arbitrator. So the parties will select the arbitrator, and the arbitrator should possess relevant expertise, of course, impartiality, professional competency, knowledge of the applicable subject matter. So stage three is that there is a preliminary meeting. The arbiter establish the procedural framework. Issue may include scope of the dispute. So there will be a preliminary meeting to discuss the scope of the dispute, applicable rules, timelines, evidence requirements, hearing arrangement, confidentiality, communication procedures. The stage four is submission of claims and responses. Submission of claims and responses. So the parties present their respective claims and responses. Claimant explains the nature of the dispute, facts supporting the claims like evidence, the remedy being requested, what you want out of the case. The respondent provides its response and may challenge the claim. Okay, so the stage five is presentation of evidence. So remember that in stage four, submission of claims and responses. What happened? You know, what happened, what they did to you, what they took from you, and what you want from the court. Then in stage five, you now present evidence. Parties may present documents, contracts, witness testimony, expert evidence, records, other relevant materials. Arbitrators evaluate the evidence according to the applicable procedural standards. Now, after the evidence in stage six, there is hearing. So the arbitrator will hear the case. So here, where necessary, the arbitrator conduct a hearing during which parties or their representatives present argument and respond to questions, which this was also done during my father's land case in the village. Now, stage seven is deliberation. Deliberation. The arbitrator considers evidence, arguments, applicable law, or contractual provisions. Relevant facts. Now, in stage 8, arbitration award. Stage 8, arbitration award. Now is decision. The arbitrator issues a decision, commonly known as arbitral award. Arbitral award. The award may determine responsibility, payment or compensation, performance of contractual obligation, other remedies permitted by applicable framework. Now, the number nine stage is enforcement or compliance. Where the award is binding, the parties are expected to comply with it. Applicable laws may provide mechanisms for recognizing and enforcing arbitral awards. Now, there are advantages of arbitration. There are advantages of arbitration. Arbitration can provide several challenges. Um, sorry, not challenges, advantage. It's advantage, not challenges, pardon. Now, one is flexibility. Parties may have a greater control over procedure and scheduling than in conventional litigation. So parties can decide when to meet, how the meetings goes compared to law. In law courts, the law fixes venue and time, and you are just going to comply without any negotiation as much. The second advantage is expertise. Parties may select an arbitrator with specialized knowledge. Privacy. Proceedings can generally be conducted privately. Number four is efficiency. Some disputes can be resolved more efficiently than through lengthy court processes. Efficiency. So this efficiency, in some court cases can last for 20 years, can last for 30 years, can last for 10 years. But in arbitration, it's just a short while. Like this land case concerning my father, it was just 2 months and judgment was reached. And the case was properly adjudicated and all parties we are comfortable. So it has efficiency compared to the normal court processes. So reduce formality. Arbitration may be less procedural, formal than litigation. So um, another advantage is that relationship preservation. After arbitration, people can still be, in fact, the bond can tighten. It preserves relationship. Let me tell you, the guy that fought to collect my father's land, after the adjudication, after decision was reached, the guy started calling me. I was telling me, you are a lecturer. Help me to find a wife now. You know, that kind of thing. We became friends, just that his manner of life was not compatible with mine. That's why we are not even friends today. But he started reaching out to me and we were talking for a long time. We spoke, but I couldn't keep up with the communication because way of life differs. So, but we bonded, we became friends after the processes. But in court cases, most times, you know, someone is favored and there is the people become enemy and yes you won but we can't go the same path, but in arbitration relationship can be preserved because it's more informal, you can adjust, you can argue, it's flexible, you understand. So there are also limitations of arbitration. Arbitration also has limitations, and one of the limitations is that it's costly. Professional arbitrators and institutional procedures can be expensive. So in some cases, it can also be expensive, you understand? So although it's in a way it's also cheap, you understand, arbitration can be cheap because it's done within a short period of time, but it can also be, especially, there are international arbitration. There are international arbitration. There are national arbitration. So some can be very expensive, but the local ones, they are not very expensive. If it is a traditional ruler, you bring maybe 2 cartons of beer, cola nuts, and maybe palm wine or hot drink, and the case is done. So the disadvantage is limited appeal. Like in the court, after the high court, there's an appeal court, but in arbitration, there's no all those appeal. So depending on the applicable legal framework, remember we said limited appeal as the second limitation of arbitration. Opportunities to challenge an arbitral award may be restricted. Number three is power imbalance. A wealthy or powerful party may have greater capacity to secure legal representation and present its case. In some cases of arbitration, a wealthy family can compromise the situation, can even bribe the arbitrator. So that also happens in the court. So it happens everywhere, though. Number fourth limitation is complexity. Complexity. Some arbitration procedure can become highly technical. Some arbitration procedure can become highly technical. Okay. Limited number five limitation is limited suitability for certain social conflicts. So it might not be suitable for some kind of conflict. For example, serious criminal conduct. It can involve is a criminal conduct should be handled by the state, not an arbitrator. Like something like coercion, domestic violence, several power imbalance, fundamental right concerns. There are some cases that are beyond the limit of arbitration. Okay, so we look at the meaning of alternative dispute resolution. We say that alternative dispute resolution refers to a range of procedure used to prevent, manage, or resolve dispute outside conventional litigation or as complementary processes alongside formal legal proceedings. Okay. Alternative dispute resolution refers to a range of processes used to prevent, manage, or resolve dispute outside conventional litigation as a complementary process or as a complementary processes alongside formal legal proceedings. Now, when alternative dispute resolution is done in a particular community, if that case goes to the court, the alternative dispute resolution conclusion can be taken to the court as an evidence. So the alternative dispute resolution can be done outside the court proceedings or can also be done alongside the court proceedings as a complementary evidence in the court proceedings. I hope this is clear. Now, alternative dispute resolution emphasizes participation, communication, problem solving, flexibility, cooperation. Now, there are major alternative dispute resolution mechanisms. Major alternative dispute resolution mechanisms. Number one is negotiation. Negotiation involves parties communicating directly to reach an agreement. There is normally no third party decision maker. So in this negotiation is one of the mechanisms for alternative dispute resolution. For example, two community groups negotiate how to share access to water sources or land. Number two mechanism for alternative dispute resolution is mediation. Mediation involves a neutral third party who facilitates communication and helps the parties develop their own agreement. The mediator normally does not impose a decision. It's just a mediator. For example, a social worker mediates between separated parents regarding childcare arrangements. Another alternative dispute resolution mechanism is conciliation. 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 Conciliation is similar to mediation, but may involve a more active role for conciliators in proposing solutions and improving communication. The precise meaning varies across legal and institutional settings. The number four mechanisms for alternative dispute resolution is arbitration. As discussed earlier, arbitration involves a neutral decision maker who determines the dispute subject to the parties' agreement and applicable legal framework. The number five mechanism is facilitation. A facilitator helps a group communicate, organize discussions, identify common interests, and make decisions. Facilitation is particularly useful in community meetings, multi-stakeholder processes, organizational planning, peace building forums. Another mechanism for alternative dispute resolution is restorative justice. So in this case, in restorative justice, you can return what you took from the person, you can apologize, you can give compensation and all of that, all of that. So there are principles of alternative dispute resolution. An effective alternative dispute resolution should be guided by several principles. One is voluntary participation. In alternative dispute resolution, there is voluntary participation. You volunteer to participate in that dispute resolution process. Number two is neutrality and impartiality. In alternative dispute resolution, one of the principles is that there must be impartiality and there will be neutrality. So where there is partiality, it means that the process is jeopardized. The third principles of alternative dispute resolution is confidentiality. The decisions are reached, the processes, the discussions should be confidential to the parties involved. Um, informed participation. Informed participation should participants should understand the process and their options. So people that are involved in alternative dispute resolution should be aware of what they are getting into. They should be aware of the of the situation. Accessibility. So another um, principle of ADR is respect. All parties should be treated with dignity. Number six, accessibility. ADR should be accessible to disadvantaged population. So this is very important in communities, rural areas. So some families cannot afford legal fees, like for lawyers, some that stays 20 years, 10 years, and all of that. But with alternative dispute resolution, you know, anyone can afford it. Anyone can afford it. So number seven is fairness. Fairness procedures should not systematically disadvantage one party. So as a principle, fairness is the key for alternative dispute resolution. Number eight is safety. ADR should not expose vulnerable parties to further harms. There should be safety as a principle. Number nine is cultural responsiveness. So the deliberation should be culture sensitive. What is the culture of the people involved? So we also look at community-based dispute resolution. Community-based dispute resolution. Community-based dispute resolution refers to process through which disputes are managed by individuals, groups, institutions, or structures within the community. These mechanisms may involve elders, traditional rulers, religious leaders, community development associations, women's groups, youth organizations, um, family heads, local peace committee. There are characteristics of community-based dispute resolution. Characteristics of community-based dispute resolution. It is one is local participation. Committee members participate in resolving disputes that affect them. Two is cultural relevance. Processes often reflect local customs and values. Number three is accessibility. People may resolve disputes without traveling long distance to formal institutions. Number four, relationship orientation. Community process often emphasize restoring relationships rather than simply determining who is right or wrong. Restorative orientation. Solution, restorative orientation. So solutions may be apology, compensation, reconciliation, community service, restoration of relationships. So there are community-based conflict resolution processes. One is the stage one in the process is to identification of dispute. Community leaders become aware of the conflict. Number two step is consultation. The parties and relevant community actors are consulted. Step three, convening. The parties are brought together in a appropriate settings. Step four, each party explains its perspective. Each party explains its perspectives. Step five, the parties and respected community representatives discuss the dispute. I said that step five, okay, step four is presentation of issues. Each party explains its perspective. Step five is community deliberation. The parties and respected community representatives discuss the dispute. Step six, identification of common interests. The groups identifies areas of agreement. The groups identify areas of agreement. Step seven, agreement or decision. Step seven, agreement or decision. An appropriate settlement is developed. Step eight, reconciliation. Where possible, relationships are restored. Step nine is follow up. The community monitors implementation. The community monitors implementation. Summary. Arbitration and alternative dispute resolution provides important mechanisms for managing conflict outside or alongside conventional litigation. Arbitration involves the submission of a dispute to an impartial arbitrator who makes a decision according to the applicable rules and legal frameworks. Other ADR mechanisms include negotiation, mediation, conciliation, facilitation, and restorative justice. Thank you for listening.